Well, hello everybody and welcome to the KMint webinar. I'm very excited to be here to present intellectual property, intangible assets, your competitive advantage. And today I've invited a special guest to help present this very important topic for our sector. For those of you who don't know me, I'm Kathryn Williams. I am the founder of KMint Pricing and Finance Consultancy. I work across the globe with agencies of all types, so that could be advertising, PR, design, media, experiential, web, all sizes from small 2 or 3 staff right through to the big multinationals. I work with the agencies either as a mentor, my Show Me the Money mentor program, my virtual CFO service. For the larger agencies, I'll be doing professional development keynotes and workshops such as Sell Your Ideas and the Money Wheel. I also have a variety of how-to booklets and these webinars, which are bite-sized pieces of information, important education for people within our sector. So today's session is about one of my favourite topics. It's what we do every day in our businesses, is create intangible assets, as we know them, intellectual property. So to help me explore this topic today, I've invited along one of the industry's well-known legal experts, Justin Senescall. Justin, welcome.
Thanks, Kathryn. Hi, everybody. Thanks for joining in today. As Kathryn mentioned, I'm a lawyer that specialises in intellectual property law, and I've got a focus on creative businesses, and I assist brand marketing and advertising agencies to identify, protect and defend their rights. I have also established my own consultancy with Warren Brown, that you may have heard of, the founder of BMF. That consultancy is called Gut Think, and it combines a number of skill sets and professionals to create and protect ideas as well. So yeah, great to be here, and looking forward to imparting some of this information.
Fantastic. Well, Justin and I have also co-presented on stage together pre-COVID. So we know each other well and we work with agencies and clients. So today what we thought we would do is explore these topics with you. We're going to get started with what you don't know. So Justin's going to take us through some tragedies and where the agency landscape, sometimes just get it wrong. Then I'm going to present some global intel, what's happening across the world in this very important space as intangible assets become more and more valuable. I'm going to bounce with Justin as well as, the advantages that we have that you might not be aware of when it comes to intellectual property. Then we're going to walk through the basics of protecting your IP, 3 ways to sell your intellectual property through new revenue streams and the legal agreements that you might need. And we'll finish up probably 15 minutes towards the end of the hour with some Q&A. So you'll see in the bottom of your screen a Q&A option. So as we go, type in your questions and we will get to that at the end. And you can add those anytime throughout the presentation. All right, so let's get started. Firstly, you don't know what you don't know. I might pass to Justin to maybe explore some examples that he often sees as the lawyer that are playing out every day. He's very busy. Every day you get calls, I guess, and you're working on cases where the agencies in our industry just don't get it right. Justin, do you want to share a little bit about us and what?
Absolutely. As Kath says, I'm really busy with these sorts of issues, so I'm excited to share this information with you because, if the last 20 years is anything to go by, the information isn't widely known or isn't taken into account, which is disappointing. But nevertheless, hopefully everybody learns a bit out of today. So given the focus of each of your businesses and what you create for your clients, I guess the way I look at it is that you've got an opportunity to in some cases maximise the impact of an existing business offering, or for a different brief, it might be in relation to a new business idea. I suppose most of my work, as I was saying, is where the client doesn't get it right, though, through not understanding the importance or thinking there's a perceived expense or just not wanting to incorporate another process into providing the pitch, given obviously everybody's under tight timeframes and the ultimate client's requirements around timing and launch and so forth. So I do understand that incorporating a lawyer into that process is the last thing that a lot of people want to do, but in my experience, it can make the process run smoothly and in a lot of cases maintain a more solid relationship with the client.
I might just add in there, Justin, if I may, some of the future webinars that I'll be putting on are about this exact point that you've just raised. Agencies don't have lawyers on side necessarily, and you need to surround yourself with the wise counsel. So it's really not a difficult or onerous task to question or raise a point with someone around your wise counsel, i.e. your lawyer, so that you do have this covered off when you're at that pitch stage. I think it's very important, and I guess this is why we're putting on the webinar today, to show you how you might incorporate this into your process to be best practice, which your clients expects you to be.
Sure. So I suppose just to keep it interesting and knowing that everybody loves a great war story, I've integrated a few into our material today as we go along. Okay, so I suppose the idea here is to practice good governance. One client agency said to me, one ultimate client, so not so much the agent client that the agency was doing the work for, said to me, well, how can the process of not insuring, in this case it was a rebrand, and they said, how can the process of not ensuring the brand is available not be part of the process when we're paying, in that case, it was a lot of money for that actual service. And I suppose just thinking back over the years, and there have been a lot of examples, and unfortunately, like a lot of the ones you can find online, I can't say who the issues are about, but they do illustrate the point nevertheless. So one of the examples I had where it went wrong was a large agency, in this case, that will go nameless. The brief was for an expensive rebrand. It was, I suppose, one of those ones that would ordinarily make it to the paper for, the uneducated, thinking it was a pretty picture for lots of money. But at the time, there was no process integrated into the pitch to work out the issues about what was around in terms of other people's rights. And I did talk to them on numerous occasions leading up to that about it, but everybody got busy and moved on. So in this, for this rebrand, the agency told me about the rebrand the afternoon before it was to be launched. Nothing like a bit of notice for some work. The agency had pitched the idea probably a month or so prior, and the client had loved it, fallen in love with it. The agency thought that at 4 p.m. the day before the launch that it might be a good idea to check with me some concerns that it had about some similar brands. I told them it was an issue at about 5:30. The agency then said to me that there wasn't any time to deal with the issues, and I told them that it would be better to address them even at that late stage and potentially have an unhappy client than launch the brand the next day and potentially have an issue with the associated costs relating to pulling the brand and embarrassment and legal costs and so on and so forth. And unfortunately, in that case, my prediction came true. And within about 3 days, I think it was going back a few years now, but within 3 days of launching that business, the client had received a nasty letter, and it took probably the best part of 6 weeks from that point to resolve the issue and cost them a lot in legal fees and so forth, even though it was just a new brand. Obviously, if they had have integrated that process before those issues, it would have been a much happier exercise. And needless to say, the parole agency didn't receive any more work from that big client after that. So, yeah, that one sticks in my mind a lot as well.
It's a really great example, and it plays out every day. The thing is that your large agency or small agency doesn't really matter, but the large agencies also miss a trick here because people are not educated in our sector to understand this. So it's really important, and I guess thanks for attending this webinar so that you become enlightened. It's the whole point of putting on this professional development session. And as Justin said, in this example, their agency that he was working with became aware of the predicament and the possible infringement nasty letter that may arrive. So there are practical steps you can take, and we're going to go through that towards when we get down into the webinar. The other thing I wanted to just point out there is that your clients, and if they're a big brand, a well-established brand, they will have lawyers that should be looking at this as well. So if you have missed a trick, at least have a slide in your proposition deck that raises it, who is going to look after the intellectual property, so that if it's not you, you're clear the client is going to focus on that. Their competitors will also have proactive lawyers whose job it is to be monitoring any possible infringements. So that's how this nasty letter, these cease and desist letters appear, because lawyers for the competitors in the market, that's their job. They've got their juniors looking for making sure that there is nobody else trying to crack into their space or launch and cause any potential infringement. So it is real, and it is just a tiny step that we need to implement in our process, and we'll show you how to do that shortly. So let's look now at why. Now, why did that letter arrive? It arrived because the competitor of the client recognizes the value and the importance of the intellectual property and why intellectual property is valuable. The intangible asset space is growing across the globe. So we're going to take a little look at that and explain a little bit more about what intellectual property is. As you probably know it as trademarks, it is a creation of the mind. And unlike physical property, computers, desks, land, buildings, it is the ideas that come out of your mind, the copywriting that when you type something down, you're translating it, your idea into fixed and tangible medium, designs, symbols, images, sounds, all used in commerce, secrets used in commerce to create income for our businesses. That's what we do. We come up with these ideas and media plans and written strategic documents. It's what we do every day. So it's really important to understand the commercial value. So the traditional types of intellectual property as the ultimate intangible asset category, it's a suite of these that become brand. The copyright, the trademarks, patents, industrial design or design, GI, graphical indications for where, and trade secrets, which are on the rise more and more as we go onto a global landscape. And I'll touch on this again shortly with some stats of everyone working from home, from their kitchens and their bedrooms, with the secret sauce, the trade secrets of their businesses. One great example, and I guess a great quote that is in James Hammond's book, Branding Your Business, is no brand means no business. And as agencies, but also your clients, think of that sort of two angles here. If there is no brand strength, then you're a commodity. And in that case, for agencies as a commodity, so many agencies, the clients think they can focus on price and pick the cheapest agency. Same with your clients. Their brand is the differentiation, a distinguishing persona. It has its own independent ID compared to its competitors. If there are many in the market and they haven't got a strong brand, they also are seen as a commodity, and we as the consumer will pick and choose based on price. So the strong branding is what, and you know more about this than I do, I'm sure. The audience lives in this space, but it differentiates, it creates assets that we as the consumer have a loyalty to. And it also helps attract the right candidates for employees working for a strong brand, for your agency as the best agency, client's brand I want to work with, i.e. Google. So let's have a look at the different types beyond IP as you know it, the different ones that we might see in the marketplace. I've used the International Financial Reporting Standards, the IFRS, Standard 3, which actually sets out the different categories of intangible assets. We're today mostly looking at marketing related to trademarks, trade dress as well, the way we wear uniforms and our products are packaged, as well as design. We won't be looking at patent and some of the more complicated today. But be mindful too that literary works, whether it's books or strategic documents, musical works, in fact, next month's webinar is about music and the power of the jingle. Anything else in here, audio that we're creating, the minute you create it, you own it. Software, processes, trade secrets, we'll touch on a little bit today. And this is becoming a topic that I'll be speaking a lot more on about this year and protecting those market-related intangible assets. Why it's important? It's because we're in the knowledge industry. So we've moved away from manufacturing into this intel, which is all online, and the knowledge that we have in packaging, and the world is flat globally selling this through the internet. So over the years, as you can see on this slide, I know it's a little bit busy, but I just thought it was worth showing you, for example, trademarks, patents, and design grants. The increase that we can see, and particularly in the last few years, and this is to 2018 data, but 19, 20, and 21, there's been no slow up on this, particularly on marks, trademarks themselves, and patents continue to rise. This is a global focus, and there are some businesses, even small businesses, that are avid here, and the number of trademarks that are applied for and granted every year increase. In fact, the intangible assets account for about 85% of business value. And in our sector, when all we have are our ideas and our human capital, our people, that makes complete sense. Your agency, it's your ideas, your clever people, and what you're producing. None of it is furniture, it's intangible, and that's what you sell. So the value of your business is based on intangible assets. And so I really want you to understand and see that today's session is to help you recognize what you've got, learn how to protect it, and commercialize it. Let's take a little look at our own industry. And Justin, again, let's maybe talk about, how agencies fall in a heap, really, and it's quite common. I see it as well, even from a finance position, but from a legal standpoint, Justin, what do you see in the landscape with agencies and their own brand assets?
Absolutely. I think that the most common thing is that I see is that people are just don't have an understanding of what this umbrella term intellectual property means, because we can't, it's intangible, we can't see it. But I guess today, everybody listening in, you are probably one of the biggest examples of generators of these types of rights, whether it be for yourselves or on behalf of clients, that whether you know it or not, you already have generated a lot of these rights that we will go into a little bit later, such as in the case of copyright, which is an automatic right that you don't need to do anything to be the owner. So in a lot of cases, and I think as we describe some of the slides, you just don't know what you don't know as far as your rights go. So if you did a little bit of checking, you'd be quite surprised into working out what you could have Kath value for you in a lot of cases, because it doesn't require you to do much other than go digging in your records to see what you actually have developed over the years. So a few other sort of common misconceptions that I see a lot of around other elements that people think mean they own their intellectual property. One of the main ones for me are domain names. So obviously you might generate website content and look and feel for a client, but the actual URL or the domain name itself is just a license. It doesn't give you any ownership in that name. It just gives you a right to use it when you speak to, or at least license it from the registrar, whoever that may be. So, and for those reasons, it's difficult when someone comes along and registers, using Nike, for example. If they came along and registered Nike, NikeClothing.com, if they didn't have that it's not so much about the domain name there, it's about the breach of the trademark that we'll get into later that does give you a right. A couple of other examples in this similar vein are company names or business names. So again, they don't give you any ownership in a title sense. It's just often from a fair trading point of view for people or customers to be able to find you by the name that you are using. So again, no ownership in those. So it's really focusing in on trademarks, which we'll speak to a bit about today, obviously, and securing some legal rights in those, which will enable you to monopolize that name or that logo, such as in some of those examples of those brands, obviously, that you'd be across in the slide there, where the visual elements of those logos themselves can be protected and owned, so that, for example, in the case of Ogilvy, if someone were to start up an agency with a similar style of font and you were mistaken into thinking that when you looked at that from a distance that it was their brand or something of that nature, then the trademark and other rights would enable you to protect that. So yeah, interesting topic. I think, Kath, we wanted to have a bit of a poll just to see.
Yeah, I'm going to launch a poll, and I'm going to ask you all if you know if you own your own brand, and you're going to say, yes, I do, or no, I don't, or I'm not sure. So let's see how I go with this. So if you can type your answers in, and I'll then tell you what the results are. I did think it was interesting what Justin said about the URL, that it is actually just a license, that you don't actually own that. So that was, these are the things that you need to educate yourselves and your team about. So if you're creating URLs for a client, if you're a digital agency, web, or any of those types of businesses, that, yeah, it's just a license. It's renewable with a supplier. So we're actually talking about the brand marks that you're creating every day. The word mark and also the logo. So the Ogilvy in typing, just the letters would be the word mark, and the visual that you can see on the slide there is the device, the logo device, the visual representation. So you'd actually have two intellectual property assets there, and you'd be creating these for your clients, and you should be recognizing them as two separate assets, saleable, two of them, two different prices. So again, we'll talk about that. So the response to the poll, 47% of you do own your own brand name. We've got 20%. Sorry, Justin?
Sorry, I was just saying, well done. That's good.
Yeah, absolutely. And be interesting to, again, you should just be sure that you're doing this for your clients, which is actually our next slide. But there's still 35% of us are not sure. So this again comes into absolute focus if you're trying to sell your business down the track. You need to have this IP for your own business buttoned down. So let's move to the next slide. I'll just close down my poll and click to the next slide. There we go. So now we're going to look at the client side. So when you're now working on client brand assets, what are sort of the types of infringement or the scary bits, Justin, that you see in this space?
Yeah, sure, no problem. So I guess, again, just keeping in mind that the trademark, this term that we keep talking about, that we'll talk in a little bit more detail, but that's the only way of actually owning legally what the name or the logo, or some other examples that we'll come up with later, that you can own. So it makes sense from my perspective as a lawyer in doing this every day that either your agency brand or from a client's perspective, it would make sense that with all of the hard work you're doing to either develop the brand for the client or investing in marketing and building your reputation as an agency, that you would want to own that. And it seems logical, but again, I mean, even from that poll, when people aren't, 35% of us aren't sure about it, then there's some rights here that you could really develop and market that to the exclusion of other people. So I guess to my mind, it's looking at it from a legal point of view. It's like spending without going through that process. It's like spending lots of money decorating and improving a house that you're just renting. It just is just not logical to me. But anyway, so I have acted for a few agencies over the years that have approached the issue in a few different ways. The first, as we all are initially, was a small local operation that developed a brand without searches, protection, or consideration for any expansion. The client had a couple of issues. First, they had to change their name after 9 months of trading because they got the attention of a competitor with a similar name that people were getting them confused with. And then, to add an insult to injury, they had to change the brand again when they didn't take my advice regarding an overseas brand when the name was already taken in one of their key markets. So obviously, it was a good problem to have in that they were really developing as a business and as a brand, but it was just so stop-start as far as the reputation that they were building in these brands that they really didn't capitalize. They had to spend time in being inwardly focused, talking to me, and then had to go through a couple of rebrands that probably they didn't need to do themselves. So that experience can be compared to another client that I feel over the course of the last 20 odd years have been really proactive in this space. They do, and they did in this example, ran searches and in conjunction with their business plan plotted out both the regions and the service scope that they thought they might grow into as they grew the business, and aligned that with their trademark strategy. So I suppose, that for them has proved to be of real benefit, because fast forward 10 years, I'm assisting them with keeping their competitors at bay that have tried to eat away at their rights, because they have built that reputation, particularly in the online space, where people still think it's a free-for-all and that these sorts of laws don't apply, which is not the case. So that's been a success story as far as I think anyway, because it's really enabled them to shut down any issues they have with one letter from me, or in some cases none. They've just run themselves, rather than having to reinvent who they are under pressure from a competitor who have good reason to stop them being who they are in a brand sense.
Yeah, absolutely.
Yeah.
I might just add in there, I quite often find, Justin, that the smaller businesses think this is just, as you started off in this webinar saying, too big for me, haven't got time for that, I'm not sure, so I'll just do nothing. That seems to be the general standpoint in the industry. And it actually isn't a difficult process. It's just that we haven't put it into our process, and we haven't surrounded ourselves with the wise counsel for things that get a little tricky. Even in my own small business, national as I am, and I'm now global, I trademarked over 10 years ago now, Show Me the Money, which some of the audience will be familiar with. But it's still not as popular as I'd like it to be. But every month I avidly and proactively search to see if there are any infringements on my mark. It's a really important, valuable mark, Show Me the Money, for all the reasons that you would think. But every month we would be writing ourselves to at least 3 or 4 potential infringers. Usually it's a coincidence. They don't know that we exist owning this mark. And that's still normal, even though we're in this knowledge economy now. It's still very normal as we all start to educate ourselves on this important topic. And probably once a quarter, I would engage a lawyer like Justin to write on my behalf because it's a bigger issue. And that might be a brand that is established with a website, with social pages, and promoting education and training, which is exactly what I do, all with the Show Me the Money logo and URL. So there's some little steps you can take, as Justin mentioned before. If you're working with client and you're creating their brand assets and naming and logos and registering URLs, maybe multiple URLs around it. So .com.au, .com, .net, register them all. They're reasonably priced, like they're $20 or so, and you're marking them up as a service, but you've got your client completely covered. Nobody else can come and lease or register a URL in that space. So think outside what you would usually do, potentially just registering the URL that they want. The same with all your assets that you need to do those searches, and we'll come into a little bit more detail on that shortly, and get it right so you don't have any infringement issues on your hands. Did you want to say anything more on this, or should we move to why assets are so valuable?
Yeah, sure. I just add, Kath, just looking at that slide, it's such a great representation of some high value brands, obviously, and the rights that they have protected. Obviously, those 6 are all registered in numerous countries around the world. The logo marks, I'll just say, and we'll get into the distinction later, but what I call the logo marks, so those representations on that page, I think have become even more valuable as each of the brands grow, given the reputation that they have, that the business can just be identified by a picture or a logo, is super powerful. And obviously a lot of those in the modern times now, that could become, and probably is in a lot of cases, they're app buttons and used in a marketing sense on the side of vehicles just by itself, and we know automatically what those logos represent. And so equally, protection of those is very important as well.
Yeah, we're going to come to monetizing that as you see a brand evolve over time in our last session of this webinar. I just want to draw your attention to 2 symbols that you'll see on the Target one, the R, and the TM on the Starbucks one. So we're going to cover that shortly on how and when you use these signs to indicate something special to your audience. But firstly, let's move on now to why it's so important and so valuable, the intangible assets, and in particular, intellectual property that you are creating. And the first one is it's the legal registration. And the second part is when you execute. So from a legal perspective, registering the attributes in the intellectual property, that's the first thing. As Justin said, your URL, you're just licensing that. But we're talking about owning the brand name, the word mark, as you would for a title deed of land. You can rent the land or lease the land, but to own the land will allow you to then build a house on it. You can't just go build a house on land you don't own. So the tangible assets in this case is the block of land and the house that you would build on it. In the intangible world, it's the idea as the intangible asset idea, which you then execute hours and times and materials. So that you can, without the idea, you can't execute. You've got to have the idea first, the intellectual property first. But you can sell that intellectual property separate to executing. You don't have to execute it. So if you're pitching, You could sell the idea to the client, your concept, your strategic plans. The client can buy that and then appoint another agency or internally to execute and produce. They're separate. Where again, in my experience, most agencies haven't registered that legal entitlement, and they're mostly focused on just selling the execution. This is probably, the idea is, as Justin said, the more the client brand sells and produces and is distinguished as something unique and special, their brand assets that you have created for them are equally growing and increasing in value. The Tiffany box being, one of the best examples in the world. The ideas are pretty much useless unless you're executing them well, and you'll know this. If a client does pick up your idea and you think they execute it poorly, you could have done a better job. That's their prerogative, as long as you've sold the idea to them. And that's when you need to use your intellectual property marks to make sure that they understand that is the valuable part. And the next step is execution and productivity. I'm just going to skip through a couple of slides you might be familiar with the Brand Z Top 100. This is where every year, the top 100 global brands are published by Kantar, and it's a source of reference that I read profusely. I'm really fascinated by it, and I think your team should be too. This is a great report that you could use as professional development in your business to understand why these intangible assets and brand assets, intellectual property, is so important and valuable. This is the slide, their infographic that they produced for 2020. I'm just going to draw your attention to bottom right, where we've got the category changes. So whether it's retail, insurance, think your clients. So beverages, beer. If you have clients in this sector, as part of your annual SWOT with your team, this is another process that I recommend you integrate. So for your annual SWOT routine with client accounts, look at these sectors in the global reports. What makes an awesome insurance brand? And if you have an insurance client, you can now talk and educate your client based on the best of the best in the world. The reason these brands that are so valuable is because they recognize the power of branding and intellectual property. And they invest millions and billions of dollars across the globe to create and protect and to market their intellectual property, differentiating their brand against their competitors. And one of the most important, techniques or ways they do this is through the sensory experience. And there's very good reason why they do this. So Justin, would you like to kind of expand a little bit on, the 5 senses: visual, which is your color predominantly, sound, audio, the power of the jingle, taste, touch, feel. These 5 senses are so important when it comes to branding, which I'm sure the audience knows. But from an intellectual property perspective, how do we protect these important marks?
Sure.
Aspects?
Absolutely. No, it's a really interesting area. They're called non-traditional trademarks just because a traditional one in legal sense is your word like Nike or the swoosh for a logo. But as what you do as business develops and becomes more creative, then the legal space has to work out ways of protecting it. And so from your point of view now, obviously sensory connection is important, and like names and logos, certain of the sensory elements can be protected and a monopoly granted for certain goods or services offered by the client. So in the example we'll show, for a particular chocolate, you can register your rights for color, and there's other interesting ones that you would hear often day to day, such as one that I was thinking of was Windscreens O'Brien, that you'd hear on the radio, that annoying jingle. O'Brien's. I can't even say it like the fellow on the ad, so I won't give up my day job. And
they pay him lots of money to say that, and they pay him
yeah, so
royalties.
good. It takes more practice than what I've given it. And the little Intel soundbite that you may have even missed when you hear their ad. So, but one that I've had some personal experience with over the years is this slide that Kath's just helped with here, is good old Cadbury and Purple for their products for chocolate. And I guess colour is really a great example of taking one element and creating a competitive advantage for your clients. So a lot of what I do with my other hat on through my other consulting business is to say, either through a client brief or your own focus in developing some alternatives, such as what Kath's talking about from a price point of view of coming up with something competitive for the client, is to say, well, colour in my legal world is protectable. It is difficult. So a single colour, for example, Purple or Tiffany's for their colour as a single colour is quite difficult, because what it's giving you effectively is a monopoly for a particular colour. But combinations of colours, such as Lifesavers with yellow and red, that's easier to protect. So often, as part of a strategy for a client brand, you could work that up to say, well, the colour in itself or the colours will become distinctive of the business and act as a business of its as a brand, of itself, which is obviously when the client has reached a reputational level of some significance. But other interesting registrations include the original pale yellow that you would have seen on those original post-it notes. That's registered for those products, and Tiffany's, as I said, for their turquoise, as depicted in Kath's earlier slide. But I guess the example here, Cadbury, really demonstrates how valuable to a business a colour can be. At my old firm, Cadbury and Darryl Lee spent 10 years fighting it out over the colour purple for chocolate products. So in that instance, we acted for Darryl Lee, which, as everybody probably knows, went into administration, unfortunately, and was resuscitated. But I can say it wasn't because of our legal fees that it went into administration. But colour marks are granted where it can be shown that the public identify the colour, so separate to the word Cadbury or separate to their logo, as a trademark. So if you took all the branding off the chocolate and just had a purple block of chocolate sitting there, would you automatically assume that that's a Cadbury block of chocolate? It was an interesting 10 years for this matter. So there was some interesting evidence put on by Cadbury that tried to argue that consumers were drawn to what it called the purple patch of the confectionery section of a store, and in that that they had strategically placed that within the other confectionery in the chocolate aisle of the supermarket. And I think probably by that stage, the judge, who was slightly overweight, was probably more interested in getting a few blocks himself just to maybe finish off in the afternoon than have to listen to this interesting evidence that was being brought by an expert. But anyway, it costs everyone millions of dollars in fees. And obviously, as I said, Darryl Lee went into administration not shortly after, but a few years later. And Cadbury ultimately has managed, in Australia at least, to secure one Pantone shade of purple for its products. It is ongoing for them, however. in the UK, for example, Nestle has taken up the fight as Cadbury are trying to expand out its scope of protection that it has for a colour, given the different types of products that it's trying to generate under the brand. So in a sense, it's resetting the issue because it's trying to move into other spaces, and that, for example, if they decided to go healthy, then people are not going to associate purple with a health drink or something that Cadbury might release. So it's really difficult going, and for that reason, there's only 350 or so colour marks that have been granted in Australia. There's probably about 60, I think, at this stage that are pending. So people do try, and it is good to have some knowledge of, from a scope point of view with your client. So
I think I would just move to the next slide and then the following one as well. These are unconventional marks. They're not things that you come across every day, but they're things that you would possibly think of when you receive a brief from a client. So whether you're talking about color or a shape or a design, it's this time that you would think it might be a great idea for your client, but you'll need to reach out. It's not your area of expertise. It's not what we don't know the legalities of it, but Justin certainly does. I thought I would just skip us into the next section and look at how, if you are doing this, whether you're just doing something unconventional like color, shape and design, or a word mark, how do you actually protect? So there are a number of legal regimes which we're going to just walk through. Justin, I might pass to you as well just to spend a minute on each of these. Let's start with a copyright, which we touched on earlier.
Yeah, absolutely. So I'm conscious of the time as well, Kath. So I thought it would be useful just to identify at a high level what rights you as an agency or for the client can attract through the development of the product or service offering that you are creating for them or for yourselves. It really is what I would see as a treasure box of potential rights. Some of which, as I was saying, and in this example with copyright, that you may already have a lot of, but in general terms, it really does enable you to develop some solutions with an edge. So,
and it's saleable. Similarly,
yeah, and saleable. Yeah, absolutely. So,
trademark, same thing.
Yeah. So just sorry, I'll just finish on. So copyright though, so it lasts. It's an automatic right that lasts a long time. So for those reasons, like 70 years plus the lifetime of the person that created it. So you can see that if you're creating something or you have created something, there's some rights there that will enable Kath to determine something quite valuable for you to sell. Thanks, Kath. I'll go just jump in. So trademarks, the ones that we've given a fair bit of time to today, they too require a registration. Well, ideally they require a registration process. There are what's called unregistered trademarks, but I won't get into that today, other than to say if you do go through this process, or the client does, it means that you granted a monopoly that is renewable every 10 years, which can be quite powerful given how long some of the other rights last. It's fairly cost effective, and we can discuss that later if we need to. One of the other examples that's interesting are design registrations. It protects the visual appearance of a product. For example, the Apple iPods design that we touched on earlier, it too requires registration process, and it can be protected for a period of 10 years in each country that you're using it. So again, can be quite a distinctive way of generating an edge for yourselves or for your clients. Not going to get into this one today, other than to say, if the scope of what you're doing is a new process that the client has developed, make sure that you have the client speak to somebody about it, because often disclosing the process or the invention can be fatal to being able to get these rights. So quite a powerful way of protecting yourselves. And then trade secrets, Kath.
That's my favourite topic this year.
Favourite topic, yeah.
I'll be talking more about how you protect your secrets in your internal processes a lot more in some future webinars. And that's really important too, because particularly with staffing and everybody online sharing your special sauce. Let's move into our last section, which is all about how to sell it. And I think the most important things here are the intentions of when you're selling your ideas, whether that be the copy that you've written, so strategic plans, content for web work, PR plans, the visual representation of that, so your logo marks, your brand ID guidelines, and what is it local, as Justin indicated, a great example where maybe the client is local but has vision to expand globally. And the intention at the beginning is really important. Then we'll look at your intangible asset management, which is what this is all leading to, is internally having a process and a system, a simple 3-step system, which we can explore a bit more, and then reporting the financial commercialization of it. So starting with intentions, Justin, a little bit about what you see, and I guess you can extend on that earlier example.
Yeah, absolutely. So I think the client's intentions need to be understood clearly from the outset. Many clients, big and small, are driven by price, as you all know, and an expectation that you'll do everything for them for that negotiated price. Some of the clients understand intellectual property and some don't. And those that do will try and secure them without paying a fee as well. So it's a bit of a double-edged sword. So it's important to protect yourself and determine the best outcome for you and or the client, and set expectations clearly from the beginning by determining the scope of their brief and their budget. I see a lot of instances where they're expecting, for example, a brand to be available throughout the world for $6,000. It just doesn't happen.
So your contracts and getting it right. And even if your client doesn't know how far it's going to grow, your contracts, your agency client contracts should allow for that. And think of other best practices in other sectors about the rollover fee and getting that scope really tight so that you do have a second bite of it if they do expand.
Yeah, exactly. Okay, I just thought that we would tell you that there is some relevance to these pictures here of Angelina and Jolie. We're not just trying to see if you're awake. But for me, it symbolises the importance of the brief. And just share a quick war story that I have from a few years ago. An Australian music act that, unfortunately, I'll have to go nameless for the sake of this, had prepared a business plan, and the agency at the time had disregarded the fact that the client had aspirations for international stardom. They should have known that, being a music act. Fast forward 2 years and the band had real traction in the Australian market and came to see me to protect their brand internationally. Met with the lead singer 1 week and went off and conducted some searches of the key markets that they wanted to tour under that brand. And the following week, we met to discuss my findings. Now, my boss at the time asked me what I'd found, and I told him that unfortunately they wouldn't be able to use the brand in a couple of their key markets, including the US, because there was already some registrations there. When I looked up, the lead singer who was sitting at the other end of this board table was going white. And it was quite unusual given how many tattoos he had and a bit of a tough guy image. And my boss was laughing and said to the lead singer, "Show Justin your back." And upon which the lead singer lifted up the back of his T-shirt, and he had the unavailable brand tattooed in thick black ink across his back like a rugby jersey. So unfortunately, like Angelina, he had to get creative with his tattoo and change what it said. So it's always reminded me that the process and the checks are really important.
I think that's a great example, a humorous one, the Angelina one as well. But how it plays out from a commercial viewpoint is per this next slide. This is Nike. Now, we know it today as the swoosh on its own. It's grown in brand awareness that we no longer need the word Nike with it, the brand name. And originally it was Blue Ribbon Sports. On average, every 7 years, they've evolved and extended they've redone their brand. The evolution is something your clients might experience. So when you're creating an idea for today, look at the history. How long ago was it that your client created something similar? How long did it last? And look potentially at the future that this might be done again and again. So iterations. And each time, if your fee is $2,000, is that sufficient, for example, for a 7-year usage? So again, those are intentions and your pricing around it. So predictably, it's possible that your client will expand and will evolve, and you might have future revenue streams. So look at it that way. So that's through the intentions. Managing intangible assets is just as important. So looking at a process internally, a due diligence process, I recommend you actually look at how you would create this basic desktop search for your client's brand, everything we've spoken about in the session today, clarifying your application process for the client, whether the agency is doing it or whether the client legal team is doing this process, registration, using the signs and symbols, making sure that you use them across all your slide decks, your presentation decks, as we saw earlier with the Starbucks trademark and the Target R registered symbols and signs. And this could be potentially this due diligence, a new service, which takes us into reporting those additional revenue streams. Straight away, I would be recommending you in your slide decks to use the signs and symbols, to have a slide dedicated to intellectual property best practice, to have that mapped across your agency client contracts so that there is a limiting scope for if they haven't purchased the intellectual property rights. That would have been as an outright sale for the idea, separate to the time and material execution, or they're going to license it from you. So if they haven't got the 50 or 20 or whatever your fee would be for that outright purchase, perhaps they're licensing it. So even $2,000 a year, which might fit within their budget, if they're going to use it for 7 years, that would be $14,000. So it's a considerable option for a client to see a lower amount. And there are other ways to monetize that. If you can't reach agreement on this, then it might be that you're with compliments allowing your client to use the intellectual property, these assets you've created for, say, a year, get the scope right, and then in a year you have another opportunity to review how it's being used and a price. So that whole process should be due diligence, that you will be providing that service and marking up for client, as well as how you're going to sell that intellectual property, as in the land upon which you would execute. We've come to the end of the session, so I'm just going to wrap up with the summary of the global recognition that we spoke about. It is something, the knowledge economy, that you really, I know you're attending because you're interested in it. There is a competitive advantage, so be protectful of that. You use the signs and symbols that we've explained to you today, communicate it, talk this way, use this language, and commercialize your ideas. Now, for the Q&A, if you've got any questions, I've seen a few that have been typed into the panel, which is with Justin. How early should an agency reach out to you for help?
Yeah, thanks for the question. Great one. What I try to do is enable you or the agency to do some of the work yourselves to begin with, and often that's just, I'll just come and have a coffee and give you an idea of what I'm trying to achieve for you to give you a better result. And often that might, in the case of a rebrand, it might be to show you the relevant factors and websites for you to check yourselves. And if you had a new brand and you're not sure about if it's going to be able to be registered, or if it's too close to someone else's, then I can show you some of those searches that would be conducted. If it then clears your checks, and often Google Google is your friend, as they say, because if it doesn't have a reputation on Google, it's probably not worth worrying about. So often just looking at Google is a great way to go. If there's a brand that's the same as that has some presence on Google, then, you know, and it's for a similar product or service, then I'd start again. But if it clears all of that and you're happy with it, then I would get involved after that stage.
Very much so. I find the same thing actually with clients that I'm working with when I'm assisting with the quote and the proposal decks for their prospect or for their clients. I'm always advocating for at least a due diligence process to just check, have a conversation with Justin if it's not clear. I do believe account coordinators can help with the desktop search. And then if you're working with global clients, then again, I would definitely involve Justin. It's a service that you would engage and add a markup to for your time and management of that, and then on sell to client. Unfortunately, we have come to the end of our session today, and there are lots more questions still left that we haven't answered. So I urge you to write to Justin or myself, and we'll be very happy to answer those and help you to commercialize all of the valuable intangible assets that you create. Thank you very much for attending today.